Hello Year 11s and welcome to this video on the relationship between Parliament and the courts.
There are 4 things that you need to do while you're watching this video.
The first thing is to take the very best Cornell notes you can. The second thing is to use the pause and rewind functions. Use the pause function if you need to stop this video to make notes. Use the rewind function if you think you've missed out on information and you want to go back over that information. The third thing that you need to do is have your vocabulary sheets open in front of you. You need to write into your vocabulary sheets the definitions of any important terms and also the meanings of any other words that you may be unfamiliar with.
And the 4th thing that you need to do is have your summary books open in front of you. As we go through this video, I'll give you some guidance about what to write in your summary books.
Once you've finished watching this video, please read the pages from the textbook referred to on this slide. And if you find any additional information that you think is useful, supplement your Cornell notes with that information. The learning intention for this video is that you need to be able to explain the relationship between Parliament and the courts. Please write this learning intention down in your Cornell notes. Let's get started then. As we've seen, the primary role of Parliament is to make laws. Parliament makes laws by passing statutes, which are also called Acts of Parliament or legislation. On the other hand, the primary role of courts is to resolve, that is, to decide disputes. So, for example, in a criminal case, the role of the court is to decide whether the accused is guilty or not guilty of a criminal offence. And in a civil case, such as where a plaintiff sues a defendant for negligence, the role of the court is to decide whether to uphold the plaintiff's claim or to dismiss the plaintiff's claim. It's only in the course of deciding these disputes that the court, or more specifically the judge, might make a law. One way in which a judge may make a law is by creating a new precedent or modifying, that is, changing an existing precedent. The judge will do this where the case that the judge is deciding is not covered by an existing precedent, that is, it's not covered by a previous court decision. These precedents form part of the common law, that is, the law made by judges. Another way in which a judge may make law is by interpreting a statute that has been made by Parliament. A judge may need to apply a statute in deciding a case that they are hearing, but either a word in the statute might be ambiguous, that is, have more than one possible meaning, or it might not be clear whether the statute should apply to that case. We've seen that in the studded belt case, the court had to decide whether a studded belt was a weapon. The judge had to decide this because the accused had been charged with carrying a weapon in public, but it was unclear whether a weapon included a studded belt. That is, the meaning of the word weapon in the statute was ambiguous. Similarly, we've seen that in the Kevin and Jennifer case, the court had to decide whether it was intended that the Marriage Act should allow 2 people to marry where both had been born as females, but one had had a gender reassignment operation to become a male. Gender reassignment operations were unknown when the Marriage Act was passed in 1961, and so this act simply provided that there could only be a marriage between a man and a woman. Now, in that case, the judge had to decide whether a man included a person who was born as a female but had had an operation to become a male. Put another way, the application of the Act to the Kevin and Jennifer case was unclear. Of course, now same-sex couples are allowed to marry, and so the Marriage Act no longer provides that there can only be a marriage between a man and a woman. Now, when judges interpret a statute, that is, when they give meaning to words in a statute, then the judges may be creating a precedent. And this is because lower courts in the same court hierarchy must give the same meaning to those words when those courts are hearing a case where that statute applies. The important point, though, is that courts may only make law in the course of deciding disputes. This means that before a judge can make a law, a party must bring a case to court, and that case must raise a legal issue that has to be decided by the judge. In this video, we are going to be looking at the relationship between the courts and Parliament in lawmaking. And we'll see that there are 4 relationships. These relationships are illustrated on this slide, and I'll talk about each of these relationships in more detail. But for the moment, I'll just summarise these 4 relationships as follows. First, courts apply and interpret the law made by Parliament, that is, they interpret statutes. Second, Parliament can codify a law made by the courts. This means that Parliament can make a law, that is a statute, that includes a law made by the courts. In this way, the law made by the courts becomes a law made by Parliament. Third, Parliament can change or abrogate, that is override, a law made by the courts. Parliament will do this if it disagrees with a precedent that has been made by the courts. And fourth and finally, decisions of courts can influence Parliament to change the law. We're now going to look at each of these 4 relationships between Parliament and the courts in more detail. The first relationship between Parliament and the courts is that courts apply and interpret the law made by Parliament. That is, courts interpret statutes. A court will need to do this where the meaning of words in a statute is ambiguous, that is, where those words have more than one possible meaning, or where the application of the statute to the case before the court is unclear. A consequence or effect of statutory interpretation is that the court gives meaning to the words in the statute.
And the meaning that the court gives to those words might create a precedent.
So, for example, in the studded belt case, which is also known as Deng and Tarola, the Victorian Supreme Court had to decide whether the word weapon in the Victorian Control of Weapons Act meant something that could be used to injure another person, or something the primary purpose of which was to injure another person. In that case, the Supreme Court interpreted the word weapon as meaning something the primary purpose of which was to injure another person. Now, this created a precedent about the meaning of the word weapon in the Victorian Control of Weapons Act. This is a binding precedent for lower courts in the Victorian court hierarchy, such as the Magistrates' Court and the County Court. That is, when these courts are interpreting the word weapon in the Victorian Control of Weapons Act, they must interpret it as meaning something the primary purpose of which is to injure another person. But the meaning that the Supreme Court gave to the word weapon is also a persuasive precedent for higher courts in the Victorian court hierarchy, such as the High Court, and for courts in other court hierarchies. For example, as where the New South Wales Supreme Court is interpreting a statute that also includes the word weapon. The second relationship between Parliament and courts is that Parliament can codify a law made by the courts. Parliament codifies a law made by the courts where Parliament makes a law, that is a statute, that includes a law made by the courts. In this way, the law made by the courts, that is common law, becomes a law made by Parliament, that is a statute. In your vocabulary sheets, look down the left-hand side, find the word codify, and write in there the definition of that word that I've just described. An example of where Parliament has codified a law made by a court is the Native Title Act of 1993, which is a statute that was passed by the Commonwealth Parliament. This act codified some law that the High Court made in the Mabo case. First of all, some background. When Australia was settled by the English in 1788, the English settlers, and indeed the English government, treated Australia as if it were uninhabited. Now, of course, Australia was inhabited by the indigenous people, But unfortunately, the settlers and the English government treated the indigenous people as if they were animals who were incapable of owning land. It's since become clear that the indigenous people did in fact have deep and rich connections with the land for ceremonial, religious, and day-to-day purposes. In 1991, a man called Eddie Mabo brought a case to the High Court where he argued that, as an indigenous person, he had a legal entitlement to land that his ancestors had used for ceremonial, religious, and day-to-day purposes. After hearing extensive legal arguments and considering the case for about a year, in 1992, the High Court decided that Australia's indigenous people did in fact have a legal interest in the land that their ancestors had used for ceremonial, religious, and day-to-day purposes. The High Court called this interest native title and said that where this native title existed, the indigenous people were entitled to continue to use the land as their ancestors had used it, provided that the land was not being used for some other purpose that was inconsistent with native title. So, for example, where a person has bought land and built a house on it, then the indigenous people could have no native title in that land because they couldn't use the land at the same time as the house owner was using it. On the other hand, where the land is being used for grazing cattle, and it could still be used by the indigenous people for ceremonial purposes, just as their ancestors had used that land, without preventing its use by the cattle, then those indigenous people had native title in that land and could use it for ceremonial purposes. The Commonwealth Parliament thought that this law, as made by the High Court, was very good law, and so the Commonwealth Parliament passed the Native Title Act in 1993. The Native Title Act recognised the native title of Australia's Indigenous people as decided by the High Court. This Act also set out a process for determining when native title existed in land and for how that native title could be taken away, that is, extinguished through the payment of compensation to the Indigenous people. Now, the Native Title Act is over hundreds of pages long, but at its heart is the concept of native title, which became part of the common law because of the High Court's decision in the Mabo case. By codifying the concept of native title in the Native Title Act, the Commonwealth Parliament made this common law into statute law. The third relationship between Parliament and courts is that Parliament can change law made by the courts. This is because Parliament is supreme or sovereign. We've already looked at the principle that Parliament is supreme or sovereign in a previous video, so you should have the definition of this principle in your vocabulary sheet. That principle is that Parliament has the final lawmaking power, which means that it can repeal, that is remove, and amend, that is change, its own laws, and it can make laws that change or abrogate, that is override, court-made law. An example of this is Trigwell's case. In this case, Mr. and Mrs. Trigwell were driving along a highway when another driver swerved to avoid some sheep that had strayed onto the highway. This driver crashed into the Trigwells' car and was killed, and while the Trigwells survived, they were seriously injured. The Trigwells sued the farmer who owned the sheep, saying that the farmer was negligent in not ensuring that he had fences that were sufficient to keep the sheep off the highway. Now, there was a long-standing principle of law that was made by the courts hundreds of years ago that farmers are not liable for injuries caused by their stock, that is cattle and sheep, straying onto the public highway. The reason for this rule was that farms in England were typically not fenced, and the view was taken that people who were riding in carriages or riding on horseback had a responsibility to drive or ride carefully so that they could avoid any stock that strayed onto the road. Of course, times have now changed and we have motor cars that speed along highways at 100 kilometres an hour or more. However, in Trigwell's case, which was decided in 1979, the High Court decided to uphold this long-standing principle of law that farmers were not liable for injuries caused by their stock straying onto the public highway. The reason the High Court did this was because the rule had been part of Australia's law for a very long time.
And they felt that they shouldn't change that law.
Well, after Trigwell's case was decided, the Victorian Parliament decided that the law should be changed and that farmers should be liable for injuries caused by their stock straying onto the public highway, because it would be negligent for farmers not to have fenced in their stock so that they couldn't stray over the road. Accordingly, the Victorian Parliament passed a law, that is, it made a statute, that abrogated, that is, overrode, the common law principle as stated by the High Court. This statute effectively provided that farmers could be liable in negligence for injuries caused by their stock straying onto the public highway. In your vocabulary sheets, please make sure you look down the left-hand side, find the word abrogate, and define it to mean override. This now brings us to the fourth and final relationship between Parliament and courts, and this is that decisions made by courts can influence Parliament to change the law. For example, a judge might make comments about a statute in the course of deciding a case. The judge might do this because the judge thinks that the statute operates unfairly in a particular situation. These comments, which will be over to dicta, may be picked up by Parliament in the sense that Parliament might then pass a law which amends, that is, changes, the statute so that it no longer operates unfairly. Another example is where a court makes a decision or applies a statute or a precedent in a way that Parliament thinks is unfair or unjust. For instance, around 10 years ago, there were a number of cases where people were killed by what became known as cowards' punches. This often happened when young people had been drinking and they got into an argument. As the victim walked away, the offender would come up behind the victim and, without warning the victim, would punch the victim in the head or the neck. The victim then died, either because of the punch or because they hit their head on the ground when they fell down. Well, when these cases came before the courts, offenders were typically sentenced to a few years, perhaps 5-6 years in jail. However, the Victorian Parliament considered that these sentences were not sufficiently long. As a result, the Victorian Parliament passed the Sentencing Amendment, Cowards Punch Manslaughter and Other Matters Act 2014. This act requires the Victorian courts to sentence an offender to a minimum of 10 years jail where the offender is found guilty of killing the victim with a coward's punch. So this is a situation in which decisions by the courts have influenced Parliament to change the law, in this case to make it tougher.
On this slide, I've set out a table that you need to complete and include in your summary books. In the first column, I've set out each of the 4 relationships between Parliament and the courts that we've looked at. Using the information that I've given you in this video, you must now complete the description of each of these relationships in the second column and include a summary of an example of each of these relationships in the third column.
That now brings us to the end of this video. By now, you should be able to explain the relationship between Parliament and the courts. Please remember to read the pages of the textbook referred to on the first slide. If you find any information in that reading which you think is useful, then supplement your Cornell notes with that information. Thank you for your attention.